Hello, I'm Natalia Angelini.
And I'm Deanna Betlej.
Welcome to Helen Estates. You're listening and watching episode number 625. I'm so happy to be podcasting for the first time with Deanna today. And we're going to be talking about a case called Grant Thornton and the province of New Brunswick. It's a Supreme Court of Canada decision. It's a recent decision dealing with not necessarily the most exciting subject matter, limitation periods.
Limitations is so exciting.
But we still thought it is important to cover because there's quite an interesting, change that's happening here in this case. So why don't we get into the facts?
Sure, I'll provide a brief summary. So in the fall of 2008, Atkin Group was having some financial difficulties, and the company was looking to get some loan guarantees from the bank, but the bank required that these loan guarantees were first approved by the province. And in order to approve this, they said that they needed to get an auditor to do an audit of the entire company. So in April 2009, the province agreed to give a $50 million loan, conditional again upon this external review. So in May 2009, Grant Thornton delivered a letter to the province saying that was undertaking to do the audit. And then in June 18th, 2009, the audit report was delivered to the province. And then on June 30th, 2009, relying on this report provided by the auditor, the province guaranteed $50 million in loans. And then
hefty sum.
A lot of money.
Yeah.
And then 4 months after receiving this loan, Atkin Group actually shut down.
Yeah, they were having financial difficulties, and this sort of leads to where we get into limitation period issues arising, because the report was issued, there was a 2011 report, right? February 2011.
Right.
Yeah, and that's the report that the province got after retaining another accounting firm. And it was through that report that they discovered that Grant Thornton didn't do the job that they had thought they had done.
Right. They weren't accurate enough. I think they said that the company was struggling financially with $1 million or something, when it turned out to be millions and millions of dollars that they were behind on.
Yeah. And I think even earlier, tell me about what was happening. I think in March 2010, even earlier, there was another, I think that's when they had to pay out the guarantees. It was March 2010, that $50 million, right? And then not long thereafter, in 11, they had received that report in terms of Grant Thornton's role.
Right.
However, the key here is there was no lawsuit commenced by the province until 2014.
Right. So
tell us about that.
So the province actually brought a claim for negligence against Grant Thornton, which Grant Thornton was like, you're a little bit late. So they moved for summary dismissal because of the limitation period, which is when the motion judge agreed, and they were like, this case is barred. Two-year limitation period has come and gone. You can't bring the claim. And so that's when the Court of Appeal had to get involved.
Right. So this is where we get a bit technical. So when we look at, the considerations of the court, the motion judge's view of this, on the issue of the limitation, is that on the issue of discoverability, is that the time limit, the province has to have knew or ought to have known that it had prima facie grounds to infer that it had a potential cause of action against the auditor. So the judge applying that test said, you're out of time, right?
Right.
And on appeal to the Court of Appeal applied a much more liberal standard and said that, so the governing standard is when I want to make sure I get this right. When a plaintiff knows or ought reasonably to have known facts that confer a legally enforceable right to a remedy. And the court found that this can only exist if the plaintiff has knowledge of each constituent element of the claim. Right. So if that standard were maintained, it's great for plaintiffs, right? Because to know each constituent element of the claim is not always the case, right? There would certainly be broader timeframes allowable before that is a place where a plaintiff lands. And so Grant Thornton appealed to the Supreme Court of Canada, and maybe tell us a bit about that appeal and what was the outcome of that.
Sure. So a year later, the Supreme Court of Canada had a different conclusion on the Grant case. Here, the court said that they're going to be enforcing a new standard for when a plaintiff has the requisite degree of knowledge to discover a claim. And going forward, the new standard to be enforced is whether the plaintiff had knowledge, actual or constructive, of the material facts upon which a plausible inference of liability on the defendant's part can be drawn.
Right. And so this is, I mean, at the outset, I mentioned that there's sort of a change, but I guess I want to qualify that because not really. I mean, the court is being faithful to the discoverability principle. And so I guess it's more of an affirmation in terms of, you know, this is the applicable test. And so it's helpful to us all as litigators, whether it be estate litigation or otherwise, to have clarity on this point.
Right. So I think what one of the main differences is the plausible inference of liability. So what the court really came down on, that the degree of knowledge required to discover a claim is higher than just mere suspicion or speculation. You need to truly know the underlying principles of discoverability.
Right, right. And the court and the court's reasoning is, right, it's unfair to deprive a plaintiff to bring a claim before it can reasonably know that the claim exists. So I think the court has struck a nice middle ground.
Right. So I think it's also important to mention that this was enforced in New Brunswick. And I think going forward, it's also going to be enforced in Ontario and other common law provinces.
Yeah. Yeah.
So big changes.
Yeah. So unless you have any more thoughts, Deanna, I think that brings us to the end of our podcast.
No, I think we've covered all the bases.
Okay, great. So until next time, we want to thank you for listening and for watching. I'm Natalia Angelini.
And I'm Deanna Betlej.
Should you have any questions, please email us at info@hollandhull.com or leave a comment on our blog. Thank you.
Thank you.